recording here that everyone can refer back to this later. If there's any particular areas that you kind of want to revisit, or anyone who wasn't able to join us live today can obviously access it as well. But first of all, I really appreciate everyone joining today. My name is Michael. I'm a lawyer and the head of partnerships here at Conscious Counsel. We're a boutique law firm who specializes in the areas of health and wellness, yoga, Pilates, health coaching, that type of a thing. So, goal today is, ahead of time, Rachel was able to kind of pass along some questions, and we kind of talked through a few different areas, topics that we thought would be, of particular value, for everyone to kind of get some information and, hopefully provide some clarity on some of these areas. And there were some really good ones, some, very common ones that questions I get a lot from clients, and then some, not so much that I thought were also, great areas, to talk about as well. So, with that, I think we can just kind of go ahead and dive in here. And the first one on the list, kind of being one of the most common questions that I get from clients, and it's independent contractors versus employees, right? What's the difference? How do you tell, right? How do you determine who falls into what category, and why does it matter? If you got it wrong, what are the potential consequences, down the road? And so I think first it's easiest to start kind of with what are the distinctions, kind of how do you tell the difference, between the two, and make a determination, because this is something that needs to be determined at the beginning of the relationship. And just for the to eliminate kind of, or reduce confusion, just because there's so many like interchangeable kind of terms here, I'm just gonna say, like, when I'm talking about the business who's hiring the person, in lieu of using the term employer, because that implies employer-employee relationship, I'll just use like the business owner, right? And then the individual will be the person who is being hired, either as an employee or an independent contractor. That way I'm not confusing terms and adding confusion to an already pretty confusing topic. So first and foremost, this to some degree is state specific. There are certain states where, if an individual is providing what would be considered the core services of your business, so say you're a yoga studio, right? A yoga instructor who you hire would be considered to be providing the core services of your business. In certain states, California and Washington State are two that come to mind. If they're providing the core services of your business, then generally you cannot classify them as an independent contractor. So some states make the decision for you, right? But for the purposes of this conversation, we'll assume that you're in one of the majority of the states where you are allowed to classify individuals as independent contractors, even if they are performing the core services of your business. But again, it's just an area where it's important to know what the laws of your local jurisdiction, or employee counsel who knows the laws of your local jurisdiction, to make sure that that you make the right classification, and that your jurisdiction allows for that classification. But moving on from that, assuming again you are in one of the jurisdictions that allows independent contractors to perform the core services of your business, it's how do you tell the difference, and what is the difference, and how do you classify these individuals? And the thing is, the truth of the matter is, it's like a lot of things in law, is that there's not necessarily, unfortunately, a clear-cut, black and white, so to speak, answer, right? The answer is largely, it depends, right? And it's a case by case analysis. What are the details of the situation? So it's a little bit of a sliding scale, but I'm going to try to separate the two as clearly as you really can, while still allowing for the kind of the legal catch-all of it depends on the situation, right? But the most important thing, the most important factor that would be looked at to determine whether an individual should be classified as a independent contractor or an employee, comes down to control. How much control is the business owner exercising over the activities and services that are being provided by the individual. So I'll kind of provide two extreme examples because these are the easiest to classify. One side of the extreme would be the business owner controls basically everything about the services that that individual is providing. The business owner determines the schedule. They determine the rate that that individual charges for their services. They determine exactly how the services are provided. So they don't leave room for the individual to kind of come up with their own programming or their own specific services that they're providing. If all of those details are controlled by the business owner, then in all likelihood that individual is going to be classified as an employee of the business, right? Because they don't have the individual autonomy or the individual control to influence those, to make those decisions. Those decisions are all made for them by the business owner. Location is another one, like as another factor, like where is this individual providing their services. But in the health and wellness field, that one almost inevitably ends up being at the studio or at the gym or at the so that one isn't so relevant. But in other industries, to this industry, other industries where you have more remote work, things like that, then that can be a factor. Where are they do they work from an office or do they work from on their own? Equipment, who's providing the equipment that's being used, and if everything that's being used in providing the services is provided by the business owner, that's another factor that weighs in favor of that individual being classified as an employee, right? So the more control that's exerted over all of these little areas, and it's not that one of them is like the key, right? It's really like a totality of the circumstances situation of, let's look at the nature of this relationship, and let's look at the control that the business owner is exerting over all of these areas, right? And if kind of the totality of the circumstances is such that it's like, okay, the business owner is exercising a very large degree of control over over how this individual, how, when, where this individual is providing the services, then that is likely to fall on the employee side of the spectrum, right? Now let's flip the script, right? Say the business owner is controlling none of that. They say, hey, my gym, my business is open from 6 a.m. to 8 p.m. You can provide your services to clients anytime during that window. You can provide the exact services, the services as you see fit, right? So you can modify, you can, you're free to kind of put your own spin on it. You can come up with your own programming. You can set your own prices, right? Things like that. That's kind of the opposite end of the spectrum. Well, then the pendulum swings the other way. And that individual, hey, you can bring your own treatment tools to, and equipment to use, all that kind of a thing. That's going to be kind of the opposite end of the spectrum, the other extreme, to where that individual could, again, assuming the state allows for it, that individual could be properly categorized as an independent contractor. Right. So again, it's a little easier to make the distinction when you're on either side of the extremes. Right. It's when you kind of fall closer to the middle that I think people have. It's more challenging to properly identify. But what it always comes down to is that element of control. And the more control, it's kind of on a sliding scale. The more control that the business owner is exercising over that individual and how they perform their services for the business, the more likely that it would be that they are categorized as an employee.
Michael, could I ask you something real quick?
Absolutely.
So it sounds like in Washington State and in California, it sounds like all yoga teachers should be employees, not independent contractors.
Yeah, if they are, and now I'm a Florida-based, attorney, so things work a little bit differently here. But like I know there's a law, I think AB5, I think it's called in California, where yeah, it's like if the core services of the business, and there's a whole test, right? So it's not even so like, oh, if they do this, then this. Unfortunately, law like very rarely works that way, right? There's always a test, and there's always an analysis, and there's always a case by case thing. And in California, there's literally this entire test that you apply, and are you doing this, that you run through this whole list of questions, and depending on kind of what the answers are there, it'll kind of one way or the other dictate which one that they classify as. But yeah, simply put, generally speaking, if they're providing those core services of the business in one of those states, then they're in all likelihood not going to be able to be classified as an independent contractor.
And the other thing is that, so working for yoga studios, yoga studio owners, even though they might say it's a contract and they're the contractor setting the pay rates, the studio is setting the pay rates, the studio is setting the schedule, the studio
Right.
is providing the equipment almost always. And yet there's teachers don't want to be employees most of the time because they want to have their whatever their expenses and their freedom.
Yeah.
And studios want them to be independent contractors. So it's kind of like,
Yeah. Yeah,
so
definitely. There's a little bit of this kind of like hush hush, like it's an IC agreement, but really if a court looked at it, or something like, in a lot of those situations, it could end up being where they would determine that they really are in practice, like in reality, effectively an employee, right?
yeah.
But yeah, so it's a gray area, which doesn't make it any easier, right? To know. Again, the extremes are pretty simple, right? If you understand that, hey, if you're controlling everything, they're an employee. If you're not controlling anything, then they likely could be categorized as an independent contractor, right? And what you just mentioned kind of segues perfectly into my next point of like, why does it matter, right? And one is like, there's benefits, or can be benefits on both sides of the equation for someone to be categorized as an independent contractor. Taxes, a lot of it comes down to tax implications, right? As the business owner, when you have employees, W-2 employees, then you're responsible for half of the, Medicare, FICA, all those employment taxes, right? Which I think the employer's half is like 7.65% or something like that. Whereas in an independent contractor relationship, the independent contractor is responsible for all of their own taxes. Now, on the flip side, of that coin for them is that they have access to a whole different ability, that they file their taxes completely differently. So there's a whole different, the rules are different for write-offs and expenses and all that type of thing. So they could still come out ahead, even though they're paying, more of the employment taxes. But so really a big reason why, one side or the other or both would prefer for the relationship to be categorized as independent contractor versus employee comes down to employment taxes, right? Who's responsible for what?
Yeah.
And then from the individual standpoint, what they're able to write off at the end of the year. They could, if they're an independent contractor, then they can, set up an LLC and kind of run it all through an LLC. And there's some, different advantages, to doing that. So that's really kind of why, one side or the other, again, or both might want it to be categorized as an independent contractor, relationship. So,
And
and then,
Stephanie had a question too
yeah,
about,
sure.
do employees need their own? Does this mean employees, if they're categorized as an employee, that they don't need their own?
Yeah. So they
Stephanie,
are,
you assume you
if
mean
they are,
liability insurance.
yeah. So if they are legally and properly classified as employees, so meaning like W-2 employees, right? Then the business owners liability insurance should cover the activities of their employees. So obviously that's something you want to confirm with your insurance agent, right? And make sure they know that you have employees performing services on your behalf. But yes, they would typically be covered under the employer's insurance policy.
And one thing I just want to mention for all the studio owners out there, something you run into is that if you have them categorized as an independent contractor, you can't really do like a mentorship or feedback or anything like that. You know what I mean? Like you can't tell them how to do it. It gets tricky in terms of giving teachers feedback on their performance.
Yeah.
So
yeah, definitely. Because doing performance reviews or whatever, feedback, that all starts to really creep into employee land, very quickly, in terms of all that. So that's a great point. And the last, important part that's definitely, important to understand and mention is the consequences, right? Of misclassifying. You generally won't have negative consequences for like if somebody can be classified as an independent contractor, they don't legally have to be, right? You can still you can still create an employer-employee relationship with that individual, even though legally you could have elected for them to be an independent contractor. But that doesn't work both ways. If somebody has to be legally an employee, you don't have you don't have the same ability to elect independent contractor status. So why does that matter? If you miscategorize a employee as an independent contractor, you can run into issues with the IRS. And what could happen, and in typical IRS fashion, it would probably take a long time for anything to come from this. But what they can do, and what has happened to business owners, is that you all of the sudden the IRS it becomes aware of this and assesses back taxes, right, for all the employment taxes that you should have been paying on behalf of that employee, and then on top of that they can assess fines. So you could end up in a situation, and this has happened to small business owners, where you miscategorize, and then down the road you get hit with a massive bill for back taxes or a fine. And there have been businesses that have had to go under because they're running an otherwise profitable business, but who's prepared to have a 5-figure plus tax and fine assessed against them by the IRS kind of out of nowhere for something that they didn't realize that they had been doing wrong. So that's the potential negative ramification of classifying an employee as an independent contractor. Again, not so much of a concern if somebody could be an independent contractor. You can choose to make them an employee, and there might be benefits for doing so if the control over how they perform the services for your business is important and is valuable to the business owner, then maybe you do want that person to be an employee, right? And it's worth it to pay the extra employment taxes. So that really just comes down to a business decision, but it doesn't work the other way around. If somebody legally has to be an employee, they have to be an employee, and miscategorizing them can have negative consequences. So.
And it doesn't matter how many hours, because I've heard some people say like, oh, but they only teach for us like 2 hours a week. Like
Yeah,
so the amount
yeah.
of time doesn't matter.
Right. That's not really one of the factors, right? It's that 2 hour a week could just be a super part-time employee, right? If all the other factors are met that would indicate it's an employer-employee relationship, then that person could still be an employee, still be required to be an employee legally. So that's a great point too, because a lot of people might think it's that simple, right? Oh, they're just super part-time, a couple hours a week, but that doesn't really actually weigh into the equation. So that's probably the most common question that I get. And there's one other important thing to mention, is that intellectual property. So when somebody is an employee, by default, the business owns the intellectual property. If they create any intellectual property, it's considered part of their employment, in the scope of their employment, and the business owns the intellectual property. And as a business, your intellectual property, things like your processes, right, your specific treatment plans, all that type of stuff. Of course, your name, your logo, name recognition, all that is super valuable. But even intellectual property you create as part of your business is super, super valuable. So retaining ownership of that is very important. And for employees, the standard, the default is that the business, owns it, the employer owns it. But for independent contractors, it's not the same. And an independent contractor could claim ownership of the intellectual property that they create. For the business owner. So that's why it's very, very important in IC agreements to specify that any any intellectual property that's created is the property of the business and not the property of the contractor. So, but the default rules are different as would apply to an employee. So there's some nuances like that need to be accounted for in the contracts themselves. So there are some differences, and there are some issues that you would need to address, things like insurance too, requiring that an independent contractor carry insurance is a common thing, right, to make sure that they're covered for the services that they're providing, even though they might be providing them on your premises, right, making sure that they have their own insurance is a very common thing. So there's some nuances to the contracts themselves So independent of, step one, making sure that they're classified correctly, but then making sure that you have the correct agreement in place that, depending on the classification, covers everything that it needs to cover. Are there any, of course, we'll hold some time for questions at the end, but are there any other questions on that? Okay. Does intellectual property have to be explained in the employee handbook? I wouldn't say that, like, from a legal standpoint, it has to be. It's probably not a bad idea to mention it, but certainly would want it addressed in their actual employment agreement or independent contractor agreement, respectively, depending on which category they fall in.
Yeah, so one of the participants who she couldn't make it to the live recording, but was asking about, she's like, well, do I really have to have? She's like, I work for like these mom and pop studios. We don't even have contracts. And I was like,
Yeah.
oh,
Yeah.
like you might
It's
have a
super common.
contract.
It is. It's super common for people to kind of operate that way. And it's one of those things where if you never have an issue, then technically you didn't need it, right? And verbal contracts, are valid. It's really difficult if there ever is an issue and you ever do need to rectify a situation or refer back to to something in your agreement, it's really difficult to do that without a written contract, right? And so, yeah, best legal practices is absolutely have an agreement in place. But yeah, it is common that people operate just on verbal contracts or or no contract at all. But and if they never have an issue, then they might think that, hey, it's fine. I haven't had any problems. I've been doing this and it's okay. But it only takes that one time, of having a problem. And then when you have nothing to refer back to, then it becomes, well, I remember it this way. I remember our conversation this way. I remember it this way. And where do how do you solve those issues? So it becomes much, much more challenging, to solve issues and address issues that could probably be cleared up most of the times pretty quickly, by being able to refer back to a comprehensive, well-written agreement that was in place where there's really no room for misinterpretation. Yeah. So any other questions on that? Otherwise, the next topic that I had written down here was liability waivers. And just basically all things why liability waivers, what are they? Do you need them? Do they actually work, right? Do they actually protect you? I get that question a lot. And then specifically, Rachel, I know you'd mentioned, people having questions of for retreats. Are these needed for retreats, right? So first, just, basic overview. What is a liability waiver, right? Well, a liability waiver is a document that somebody will sign, ideally at the very beginning of your relationship with them, right? So somebody wants to come engage you for your services. You should have two things in place that every single client signs. One is a service agreement, right? That outlines what are they hiring you for? What services are you providing to them? What are the details of that relationship? What's the payment structure? What's the cancellation policies? All that kind of stuff, right? So basically your contract between you and your clients. At the same time, they should also sign a liability waiver or a waiver of liability. Those are kind of interchangeable terms. This is a document that specifically and clearly states that the client will not bring, they're waiving their right to bring any type of claim against you for any injuries or other, negative health, consequences, any other negative ramifications, negative adverse, reactions or adverse consequences, right? That they may have as a result of participating in your services. So the most common when you're facilitating physical movement are injuries, right? Physical injuries. So this is a document that they'll sign. They are assuming the risk of participating in your services and are agreeing that in the event they suffer any type of injury or other adverse, consequence, they will not bring a claim against you. So that's kind of what it is and what the purpose of it is. It needs to be signed in advance of them participating in your services. Ideally, at the same time when they sign the, the service agreement, just get everything, signed at once so you have it all in the client's file. But as long as, I do see sometimes people have them sign at the, right before they participate in a class or something like that. And that's okay too. They do not, I get this question a lot. It's not something that has to be signed every time that they participate in a class, or at least it shouldn't be. If it's drafted in a way, unless it specifically says I'm waiving my right to bring a claim if I'm injured while participating in this yoga class at 12 o'clock on Tuesday, January 30th, right? That would be super specific. And then, yes, that would only apply like to that class. But generally, what you'll see is a more general waiver that applies to your ongoing relationship with that client. So, this waiver, covers, them participating in your services, and you leave it more, it's left more broad, more open-ended than that, and does not specify one specific class or one specific event that they are participating in. It's more broad and covers their ongoing participation in your services. So question I get a lot, but the answer is it should be no, as long as the waiver is drafted in a way that covers the ongoing relationship. They sign it once at the beginning. Now, one thing that is very important, because some people have the misconception, well, I've heard that liability waivers don't work. They don't hold up in court, right? And this is like everything in law. There is some truth to that, but you have to dig a little bit deeper. You cannot waive liability for gross negligence at law. So if somebody is injured as a result of gross negligence, and what is gross negligence, right? It's just, in the eyes of a court, it's negligence that rises above the level of what they would consider ordinary negligence. So it's a very case-by-case analysis, right? Most claims would probably fall under ordinary negligence. If someone is hurt, their claim would be like, in you coaching them, or you providing your services, for some reason there was, that you were negligent in doing so. You weren't properly overseeing them, or something, and they were injured as a result. Most of the time, that's going to fall under ordinary negligence, right? And a waiver of liability can be applied and can be upheld for claims for ordinary negligence. If they tried to escalate the claim above that and claim, the only way that they'd be able to successfully bring a claim against you is if the court determined that you were grossly negligent in providing those services. It's a pretty high bar to clear. Offhand, I'm struggling to come up with an example to even give you of what would qualify as gross negligence. But maybe it's something like, if you had a client who came in with like a cast on their, or a knee bandage or something, they just had a knee replacement done, and you had them doing some crazy, super complex knee specific, movement that they really should not have been doing, then maybe something like that would be like, okay, that could rise to the level of gross negligence, just as a offhand example. But again, the bar is pretty high. So it's not like, if you're exercising, you really, what it comes down to is, are you exercising the level of care that like a reasonably prudent person, is kind of the general legal standard in your position. So, do you have the qualifications to be teaching the classes that you're teaching? And if so, are you using the methods that are kind of generally accepted practices, like in your field? And if the answer is yes, and you're not doing anything like so outside the scope of what would be considered normal and acceptable in that field, then it's highly unlikely that if somebody is injured as a result, that it would be considered gross negligence. Unfortunately, there isn't just like it's one of those situations where it isn't just a clear cut, oh, this is gross negligence, this is ordinary negligence. It is a little bit of a case by case analysis. But that is where the misconception of, oh, waivers don't hold up in court, that's where that comes from, is that there is the caveat that at law, you legally cannot waive claims for your right to bring a claim for gross negligence. So hopefully that helps clear it up to the extent that you can. I know still the difference between gross negligence and ordinary negligence is still very murky, but just know that it's not so simple as, oh, waiver of liabilities never hold up. Because I do get that question a lot, and some people think of, what's the point, because it won't hold up anyway.
That's useful, and it does protect you somewhat. Then it sounds like, to have a waiver.
Yeah, absolutely.
If it's just
absolutely.
Okay.
Most claims
That's great.
would fall under the ordinary negligence, right? Just ordinary negligence theory of, you were negligent in supervising, or negligent in overseeing, or whatever it was, negligent in creating the programming that they were following, right? And for some reason that negligence led to their injury. As long as the court did not determine it was gross negligence, then a waiver of liability can and absolutely would, you know, in that scenario, be legally valid. It's only for those very small percentage of the cases that rise to gross negligence, that you know, that a liability waiver could be, you know, circumvented. That makes sense.
Awesome. That's great. No, that's great to know. I'm sure that'll be a little peace of mind for folks out there who are like, I'm doing this, but is it useful? So, and that's good for us to know for yogis who are running, you know, like privates and things like that, or doing one-on-ones and
Yeah.
or running their own online classes, that yes, it's good to have a waiver. Now, even with online, Michael, like because someone's practicing at home, they could be practicing a pre-recorded
Yes. Yeah.
version, still good to have that
Yes.
waiver.
Absolutely.
Yeah.
Absolutely. So in those cases, same kind of thing. You know, when somebody signs up, if you have like access to like an on-demand catalog, right, of classes, when they purchase that, they're going to sign some type of agreement saying, hey, this is what I'm purchasing. These are the terms of, you know, I have access to this, and, you know, all of that, the payment terms, the, you know, if there's any recurring payment, like if it's a subscription model, all your recurring payments should be, you know, outlined in there. At the same time, just as if they were going to come participate in your in-person services, have them sign a waiver. And that's going to apply to all of the in-demand, you know, on-demand, you know, courses and everything. And same if it's live virtual, right? Same thing applies. That's kind of a hybrid there between the two. You know, you're supervising them, but virtually, right? And you're directing them virtually. Same thing. Absolutely, you know, want a waiver in place. Now, where it gets a little tricky, and this was not really on the agenda, but I do think it's worth mentioning, is what about social media, right? What about when you're putting out, like if you're putting out any tips of the day, or look at this maneuver, right? Or this pose, or this, whatever it is on social media, and you don't know who is engaging with that material or how, and you don't have the opportunity for them to sign anything. Because that's, you know, social media is a little bit of a double-edged sword, right? You get to reach a very wide audience, but the flip side of that coin is that now you don't have the ability to really control who is engaging with your content, or more importantly, how, right? So you can't oversee them, and it's totally possible that somebody absolutely misconstrues something that and misunderstands something that you put out there and thinks that they're following your advice, but in reality they're doing it completely wrong, and they get hurt, right? And then what happens? Well, in this situation, we actually advise having something, what we refer to as a social media disclaimer. It's not something you can have people sign because, right, that's just not how social media really works. But you post a link to it on your profile, and I've even seen people kind of cut copy paste excerpts of it into the, like, say Instagram, for example, into the caption of that post, and say, hey, you know, by following this, you know, this is for advice only. You are, you know, you're assuming the risk of following this advice, you know, and all of that. And so there are measures you can take even to protect yourself from like social media and online activity, even though you don't have the opportunity to have somebody. It effectively operates as a waiver, right? But of course you don't have the opportunity to have people sign them in advance. So, but in today's digital, you know, day and age, it's you know, it's an issue, and definitely something that you want to protect yourself to the maximum, you know, degree possible.
Thank you. That's good. I'm just thinking of like all the YouTube videos I have.
Yeah,
You know,
no, yeah,
just like,
definitely. Yeah, YouTube's another great example.
right?
Right? And same thing, you know, maybe at the on the main profile page, and then in the caption for each one, you know, inserting some language that
Right.
lets them know, hey, you're you know, by watching this and following this, you're assuming, you know, your own risk, is very, very important.
Thank you. That's great.
Yeah,
Um,
absolutely.
we have we have a couple of questions in the chat about
Yeah,
IC Edge, but what I'd suggest is that we push through our other
yeah,
topics and then
perfect.
try to and then return to that at the end, because those are
Perfect.
great questions, guys. They're very
Sounds
specific.
good.
Yeah.
Sounds good. Next
Excellent.
one. I think that the pace will pick up here a little bit for these next few. The copyright issues surrounding playing music in class. This is, I mean, so often an afterthought in so many different businesses that play music, right? I actually had a friend who I helped him start a restaurant, and you know, actually had an issue where he was playing music, you know, just to the crowd, you know, to the audience in the customers of the restaurant, without the proper license, and he got cease and desist letters the performing rights organizations. So I know a little bit about about how all this works. So I can at least provide the basic overview. So basically, music, there's a copyright in the recorded performance, right? And anytime you play that song to an audience, even on its recorded version, that's considered a public performance, right? So technically, you need a license to recreate that and play that, even if it's just for one or two people in your studio, right? In a private studio, even so it's not really public, right? In that sense. But yeah, technically you would be violating the copyright of the copyright owner, and it's one of those things where people do it all the time and a lot of them don't even realize that they're violating the copyright, and it's not an issue until you get the cease and desist letter, right, from one of the performing rights organizations. It's a little challenging because in the US there are 3 performing rights organizations, and to play a song you have to make sure that songs are registered with one of the 3. So you have to make sure that the song you're playing, that you have the license from the right performing rights organization, right? So it's a lot. So if you want to create a playlist, it's very possible that all 3 performing rights organizations you'd have to get clearance from to play that entire playlist. So what do you do? How do you get around this to where you're compliant? And the best answer is there are music streaming services specifically for businesses that they're a subscription-based model, but part of the subscription fee covers the licenses, right? So that anything you're playing through that platform, you're good. And that's generally my recommendation when people ask me about this, and that's what my friend at the restaurant ended up doing after he had this issue. Because if not, you can be subject to fines or a lawsuit or whatever the case is, and it's a battle that you won't win. When it comes to if you're playing playing music without the license. So again, it's one of those things that is oftentimes an afterthought. It's in all likelihood you could do it and never have an issue, right? If the performing rights organizations are never tipped off or whatever the case is. I don't even know how they go about finding the businesses who are violating this, but they find a way. And yeah, but the best way to circumvent this and just make sure you're in compliance is just by going through one of the streaming services. So like not Spotify, not just, even if you have a Spotify paid account, you can't just stream your Spotify to your business. There's other comparable streaming services, and if you just Google like streaming services for business, there's a plethora of them available who will as part of your subscription with them includes all the necessary licenses, and so that you're covered. So that's really the best recommendation I have as far as that.
So Michael, so one of my workarounds, and I just want to run this by you to see if this is actually appropriate. So it's like when I offer a pre-recorded class online, what I'll do is give people a link to a playlist, and then if they want to play it on their own, then they can, because they have a subscription to it already. But I don't play it through my computer because
that's an interesting one. Yeah, that's an interesting one. From a legal standpoint, I think that would probably fly, because you're not incorporating the music into your recorded thing, right? Because that would be a new recording. Technically, that would need a license. That would need what's called a synchronization license in order to do that. That's an very interesting workaround. So I'm not a copyright expert.
Yeah.
I offhand, that is a very creative way, and as long as wherever they're getting the link isn't like some pirated source or something, then
right.
then I think that would probably be okay.
Yeah.
Again, if it's just for them and they're using it and participating in the class like at their own home, right? That's different.
Yeah.
That is
right.
different.
That's it.
A public performance, and again, it's not public. Doesn't come down to how many people are there, right? There can be one person in what's considered a public forum for these purposes, or there could be 5 people at your own home, and that would be considered private. So it's like number of people isn't necessarily the determining factor. But yeah, that's very, very interesting. And yeah, that's creative. And I'd want to dig a little more before I gave my legal stamp of approval on that. But that is a really
tentatively possibly okay.
Yeah, exactly. I think that's a good way to put it.
Without firm commitment.
Yes. And then okay, great. So next here I had just a note about student codes of conduct. right? And how do you, be able to set the codes of conduct, for students to participate in your class? And it does happen. We see this, unfortunately, more frequently than you probably would like to think. But yeah, it does happen, and this is most appropriately. And now there's kind of two different situations. One is like in your classes, right? Like in your physical like location, and the best place to address that is in your service agreement. So you have your service agreement that outlines all of the details of the services, the payment, the cancellation policies, all of that. But that's also the appropriate place to outline, hey, what do you expect from them, right? Like you're putting a lot of what they expect and what they're buying, right, from you. But there is, two sides to that coin, and what do you expect from them in return? And you're totally free and should set codes of conduct that, if students don't live up to, that you have a right to terminate, and they can't, can no longer participate in your services. So, but again, it's much better to have this in there ahead of time than trying to after the fact say, hey, you know what, that conduct just really wasn't, it's just not, we don't accept that around here, and you can no longer participate in our services. Like if it wasn't, outlined in the beginning of the relationship that hey, you have the right to kind of to do that, and then you could run into more issues. So this is something we definitely advise having worked into your service agreement, so that everyone's expectations and everyone's are in alignment from the beginning, and there's no misunderstandings, and it's clear to everybody that hey, you have standards that you're doing everything you can to provide the best services that you can, but in exchange, you have standards of conduct that you expect your students to adhere to. So yeah, pretty simple there. And last one, we sort of touched on this a little bit, but issues surrounding online courses. So your intellectual property, your payments. So online courses have the little different element of there's a recorded product, right? There's a recorded that could be pirated or could be misused or repurposed, whatever the case is. So what we generally recommend for online courses is having an online course agreement, right? Or purely online memberships, and especially particularly talking about like pre-recorded material where the client has access kind of on demand to access the material. Making sure all of that is outlined, because those are nuances, right, that don't really apply to the live in-person class setting. So, a specific agreement that addresses all of this and is tailored specifically to your online courses is something we definitely recommend. And we have a lot of clients who do both, right? They have their online or their in-person live services, and then they offer either virtual live or virtual on demand, or both, right, courses, and just making sure that you have the right agreements in place that outline each of those relationships, because they're different. There's nuances that just don't apply to one or the other, and so you want to make sure that you have something that is specifically tailored to those nuances. Intellectual property being a big one for the pre-recorded, making sure that they don't, making them know they don't have the right to reproduce or reuse, that it's copyrighted material, and that they don't have the right to, they can use it for their own purposes, but don't have the right to then go use that material for any other purpose other than their own personal use. Payment and stuff like that should all be included in there too, what the payment terms are, just like your regular service agreement. Right, any other questions there? Those were the issues that I had. So it looks like we do have a little bit of time here for some questions. So I'll start with the ones that were in the chat. And real quick, I just need to go get my computer on the charger so I don't die here on you. This
Thank
guy
you, Michael.
back inside with me here. Didn't want to just disappear. Right.
This is so interesting. Thank you. This is
Yeah,
just
no, of
great
course.
clarity.
I hope this can help provide some clarity. Unfortunately, I know some of these issues, with the ones where there's a lot of case by case analysis, involved. It's hard to kind of, nail it down, but hopefully at least kind of informed you on what the factors are and what what would be looked at in a situation to make a determination. So here, as far as the questions, all right. So okay, the first one here, okay, classified as a IC. Information form with the IRS when I submit my taxes or file a wage claim, state level first. Okay. So this is something I would advise consulting like a tax specialist on. This is kind of the one service we don't really do at Conscious Counsel is anything tax related. So I wouldn't want to give you any misinformation here in terms of like what the procedure is to to have this, addressed. So let me just make sure I read through this so I understand the full scope of the question. Yeah, okay. Yeah, a lot of issues going on there. Definitely something that I think, I think there's like state level employment, agencies and stuff that would be the best to reach out to. The IRS could also be one, to speak to. But yeah, I think like a tax and accounting is probably where tax and accounting professional, because it impacts your previous taxes is the issue here. That where there should have been, you should have been filing under a different classification, but through no fault of your own, right? That wasn't the case. I would ask a tax, or your accountant or tax specialist how to proceed that. Like if there needs to be amendments to your previous tax returns or something like that. So yeah, something that specific, I would definitely go to the relevant professional. And as far as, the other concerns, with the employer, if anything, happened where they were, kind of, you ever got any blowback on that, it's probably something you want to talk to an employment attorney, about. So, yeah, unfortunately, I don't think I can give you too much specific information or advice there, other than those were kind of the relevant specialists that I would seek out advice. Hopefully, you don't have to go to the attorney route. Hopefully, it can just all be handled from a tax and accounting perspective. So that's where I would start. Okay, and then is there a way for employees to claim continuing education and products they buy to use with their clients that are not covered by employer? Okay, so this is a good question. So when I mentioned that, individuals who are classified as independent contractors are able to, it affects their taxes, right? And what they're able to write off. W-2 employees don't typically have that same ability, to do the itemized deductions, or it's, they're not going to add up enough to outdo the standardized deduction. Again, this is kind of unfortunately, the answer here a lot of times is the line between law and tax and accounting is very blurry. So there's a lot of questions you'll ask where the lawyer will tell you to ask the accountant, and then the accountant will refer you back to the lawyer to ask. This is one where I would think falls pretty squarely under the accountant. Ask your tax specialist, your accountant, about that. They'll know all the applicable rules about, what you can write off. Yeah, but if you were, I'm confident in saying, if you were classified as an independent contractor, absolutely all those business expenses, right, that wouldn't be covered by the business owner, are going to be valid write-offs. But when you're filing under W-2, I'm a little less certain on what the proper protocols are there. So, and then yeah, how can we determine what would be the best insurance to provide for yourself and employees, or minimums that should be needed? Okay, yeah. And again, hate to keep referring to other specialists, but the insurance companies, the insurance agents are going to be the best resource in terms of this. There could be state specific mandated minimums. So you want to definitely be aware of that, but those are definitely the right questions to ask, right? You want to make sure, hey, you want to let them know I have myself, my business. These are the services. You want to make sure you let them know exactly what services you're providing yourself, and you want to let them know who else is providing services, on your behalf, employees or independent contractors, or both sometimes. And ask about minimums, and making sure that whatever policy you have in place covers all of the relevant all of the relevant parties that and all the different moving pieces too, of the business. So yeah, those are all definitely the right questions to ask. But to really get the best answers to that, you'll just want to talk to your your insurance agent. Okay, and this is a great question about working with minors. So liability waivers, student code of conduct, and social media disclaimers. So little bit different when it comes to the liability waivers and the student code of conduct versus the social media disclaimers, for the reason that the first two there are documents that are signed, right? Like in person, when or virtually, when they are agreed to take part in your services. Whereas the social media disclaimer, has that nuance of being kind of an anonymous audience that you don't have the same opportunity to have sign any documents. So liability waivers and student codes of conduct, right, that would be worked into the service agreement, those can all be valid for minors, right? And so the same rules would apply in terms of the validity. You just would most likely have the parent sign on behalf of their minor child, right? So you just want to make it clear in the documents that, hey, by signing this on behalf of your minor child, you are agreeing, because until they're 18, that the parent has the legal right to enter into contracts, on them. They actually don't have the ability to enter into legal contracts on their own, with very few. Of course, in law there are exceptions, but they're very limited. So you actually have to go through the parent, or legal guardian. Doesn't have to be a biological parent or legal guardian in that case, who has the ability to enter into contracts. But then the same exact contracts can apply in terms of a waiver of liability, agreeing not to bring a claim against you, and the code of conduct. The social media disclaimer, I think the safest thing that we kind of recommend is putting something in there that, hey, that this material is not intended for anyone under the age of 18, right? If like there's not, unless you have like a restricted profile to where you can accept or deny like follow request, right? Which to an extent kind of, that's the only real element of control you can retain in social media. Unfortunately, the flip side of it is to an extent, it kind of defeats the purpose of being able to reach the widest audience as you possibly can. But it really is kind of the only way that you can really have any element of control over who is engaging with your content. But working something into the disclaimer of that this content is intended for adults over the age of 18. If you're under the age of 18, please don't engage in the content or follow the advice, or only do so under the supervision of a parent or legal guardian. It's just how do you enforce that, right? But of course you can't, from afar. But by having it in there, and by clearly stating, hey, this is this information is provided or is intended for those 18 or older, and advising that they only participate with under the supervision of a parent or guardian, is kind of what you can do, is kind of the extent of what you can do to make to really protect yourself in terms of minors engaging with your social media advice or things that you put out that way. So that is a great question, and again, kind of highlights how in the digital age here there's a lot of nuances to these issues, and to be aware of. Do we need an attorney to create the waivers, or can we use DIY use templates? You can do it yourself, and there's no law that says a lawyer has to be the one to do it. It just comes down to how comfortable are you in your ability to draft something that is comprehensive enough, or that a template you found online is enough to cover you. And it's just a personal choice. We work with a lot of clients who said, hey, I've been using this one I pulled off the internet for a while. And just always in the back of my mind, there's just been, I'm just not super comfortable with it. So now I want to have one professionally drafted, right? So people do it, and there's nothing, of legally, a non-lawyer can draft a legally valid agreement. But it applies to everything. That same concept would be, do you need an attorney to create your employment agreement, or can you do it yourself or use a template you found online, or your service agreement, or your privacy policy terms and conditions? So the same applies to all of these, and the answer is the same: is that no, you technically do not have to have a lawyer. It's just, how comfortable are you in doing it yourself, or how comfortable are you that the template that you found online covers you? And it's just, so it's about risk tolerance and just peace of mind, really, is kind of what it comes down to there. But from a legal standpoint, no, there is no requirement. Okay, yeah, great. That's great info, Rachel. That why yoga required 2 million minimum for teacher insurance. And I figured it would be a large number, because when you're talking about facilitating physical movement, injuries can happen, and they could be they can be expensive to rehab and all of that. So and we talk about people missing work, and so the claims can add up pretty quickly. So I would imagine that the insurance levels would be fairly substantial, like that. So that's great information. Any other questions here? I got a couple more minutes could field a couple more if anyone has any. Well, if not, sorry, was someone about to chime in, or? Okay. You're welcome, Katie.
Info.
Sorry, go ahead.
Oh, and I was just gonna say, my brain is full of.
Oh yeah. Trust me, I get it. It's a lot. It's a lot to digest, and hopefully I was able to provide more clarity than add more confusion to some of these topics. I believe, Rachel, you have the link to my calendar that can be shared with everybody. I'm happy to have one-on-one calls. Something we do here at Conscious Counsel is we provide free consultations to kind of assess your personal, like, this was all kind of general overview stuff, right? But if there's a specific area of your business or a specific question that you have, happy to hop on a call and walk through it. Generally what we'll do is kind of get a gauge for where you're at in your business, what you have in place, what and identify any areas for vulnerability where we advise having something in place to make sure you're in best legal practices. And but always happy to help. Anyone that comes from Rachel's community here is always more than welcome. So I hope to be able to speak to some of you here in the near future, and dive a little bit more into some of these areas that you might have some other questions on.
Thank you so much, Michael. This was
absolutely
really informative, and and provided some really good clarity on some what I think are can be some fuzzy areas. So
yeah,
really
they are. They're fuzzy, even for lawyers. I mean, that's you get in these situations, and that they're sometimes not they're not cut and dry, right? In terms of, like, they remain fuzzy throughout. So it's but just knowing what to look for, right? And what are the factors, and what would a court look at, or what would the IRS look at, right? In terms of how they would determine here. And just kind of knowing the factors is really important, so you can kind of identify and say, oh, hey, well, this seems, like something that would fall on this end of the spectrum, right, or the other end, and just knowing what to look for is really, really important, and that's really step one. So,
wow, hugely
thank you.
Yeah,
absolutely. I'm glad to be be a resource, and again, please please feel free to reach out if anybody needs any more specific guidance. Always happy to help.
Great. Thank you.
Absolutely. Take care, everyone.
Bye.
And Rachel, we'll start a recording with you as well, so of course you can distribute it if anyone needs to refer back to anything, or for those who weren't able to join.
Yeah, awesome. I'll share that out, and I'll share your calendar link too.
Perfect.
With
great.
people.
Great. Well, thank you very much. And it's been great to connect
with you. No, that was really awesome.
Continued success here on your tour.
Thank you. All right. Talk to you soon. Bye.